With that, Representative Stevenson, I think you have a motion before us on House File 15. And the motion is to have this bill referred to the Ways and Means with a recommendation that it be re-referred to the Judiciary Committee. Is that your motion?
Well, I think as I'm not a member of the committee, I'm not sure I
Oh.
can make that motion. I think Representative Long was thinking about making the motion.
You're right.
I wish I was a member of this committee.
We'll look for a way to get you on here, absolutely. So I think Representative Long might have a motion, however, to that effect.
Yes, Chair Mariani, I'd move that House File 15 be referred to Ways and Means with a recommendation for re-referral to the Judiciary Division, and would note that our honorary member Stevenson has brought Oreos for his first bill hearing before our committee.
Yeah, so this is Mr. Chair, my first appearance
Stevenson.
before your committee, and in honoring of the traditions of this great body, I did bring Oreos. I would note I am presenting another bill this afternoon to the Commerce Committee for the first time, so I'd ask us all to follow the lead of our Republican colleagues and be conservative in your taking of the Oreos.
Representative Stevenson, we're glad that this committee gets first dibs on the order. Please proceed, Rep.
And Mr. Chair, members of the committee, I also want to thank the chair for having advocates present in the committee hearing room today. I think that's very important. This is a difficult conversation, and I also just want to make people in the gallery and people who are watching aware that the comments that I will make and the comments that testifiers will make on this bill will be direct, and they may be difficult for some people to hear. And I particularly do know that there are some younger people in the audience here, and I just want everyone to be aware that we are going to have a really direct conversation here. So having said that, I will proceed. Mr. Chair, members of the committee, under existing Minnesota law, if a man drugs his wife and then rapes her while she is unconscious, he cannot be prosecuted for rape in Minnesota. We like to think of marital rape exceptions as an artifact of history, as a relic of a time when a woman was considered the property of her husband. But we still have a limited marital rape exception on the books in Minnesota today. And the bill that's before you today, House File 15, would repeal that limited marital rape exception in its entirety. This bill passed this committee last year. It has passed the Senate Public Safety Committee earlier this session in a separate bill. I also want to note that the bill is supported by both the County Attorneys Association and also by Mincasa, who you'll be hearing from shortly. I want to point out that this is not an academic discussion about a piece of law that's on our books that has little effect. This happens. This law has an effect on our criminal justice system today. And you don't have to take my word for it. If you look in your packets for today, you'll find a fiscal note that was prepared when this bill was being considered last session. And if you read the analysis from the fiscal note, you'll see that the Sentencing Guideline Commission estimated that repeal of this provision, particularly as it relates to the mentally impaired, mentally incapacitated, and physically helpless provision in the voluntary relationship defense, would result in 7 additional convictions each year. So this existing language is preventing justice for at least 7 people a year. I also want to note a recent Minnesota Court of Appeals decision, which was State v. Gozowicz, which came out actually on December 31st of 2018. In that case, a man had sex on multiple dates with a woman who, and I'm going to quote from the decision, according to the psychological assessments, functions at the mental capacity of a 7 to 8-year-old child. He was charged by the Brown County attorney, but just 6 weeks before trial, the man married the victim. He moved to have the trial court dismiss the case, citing to the voluntary relationship defense statute, and was successful. The trial court dismissed the case. Fortunately, the Court of Appeals reversed that decision, citing in part the possibility that interpreting the voluntary relationship defense as applying to a marriages occurring after the act would, quote, permit or even encourage an actor to marry in order to avoid culpability for criminal conduct, re-victimizing the victim. The Court of Appeals was wise to think about the incentives that could be created by a broad interpretation of the voluntary relationship defense, and I would encourage the committee to think about the possible consequences of the existing voluntary relationship defense. As an aside, That Court of Appeals decision was 2-1. So there was one judge. We were one vote away from the court upholding the dismissal. You don't have to take my word for it, though, or the Sentencing Guidelines Commission or the Court of Appeals. Play what if with that Court of Appeals decision. In a few minutes, you're going to hear from Jenny Thiessen, who lived this nightmare herself. I can recall learning in law school about 17th century English common law principle that a husband could never be convicted of raping his wife, because by consenting to marry, quote, the wife hath given up herself to her husband. I'm sure that many of us, and I hope all of us sitting here today, find those words repugnant. And I think it's time for our laws to match our values. And so now, with the chair's permission, I'll turn it over to Lindsay Bryce from Mincasa.
Thank you.
Welcome, Ms. Price.
Thank you. Mr. Chair, members of the committee, thank you for having me here today. My name is Lindsay Bryce. I am the Law and Policy Director for the Minnesota Coalition Against Sexual Assault. Many of you probably met my predecessor, Caroline, who has been here a fair amount. I'm newer to Mincasa, but I have worked with and for and next to victims and survivors of gendered violence for over 20 years, and I'm actually a former prosecutor as well. Minnesota Coalition Against Sexual Assault provides leadership and resources for sexual assault programs and our allies to prevent sexual violence while promoting a comprehensive, socially just response for all victims and survivors. And I'd like to thank the chair for your comments about inclusivity because it's one of the conversations that we're having is that it's crucial that our laws work for the most marginalized and the most heavily impacted, because if they work for those folks, then they're working for everybody. And that's crucial. I'm going to keep my comments brief today as you'll be hearing from someone who has been personally impacted by this statute and by the language that this bill would repeal. But I'm here to speak in support, obviously, of the repeal and to thank both Representative Stevenson, the co-authors, and the chair for advancing this conversation. The repeal of this bill is the same language that Mincasa supported last year. This was vetoed as part of the large omnibus bill, and this is a priority for Mincasa's legislative agenda in 2019. Just a little bit about our process. We have a public policy committee and a number of subcommittees, and then we reach out to a number of different partners as we work through what we're going to support and what makes the most sense moving forward. And in this case, we had conversations within the policy committee, and we actually, one of the concerns was whether or not there was some unintentional negative impact on folks with disabilities. That was one of the concerns that was raised. And so we reached out to the legal director of the Minnesota Disability Law Center, brought them into the conversation, and they also supported the repeal of this and said, thank you for being concerned. We don't see any clear and unintended consequences. So that our process is both Mincasa and it's pulling in partners, and we fully support this. Thank you for your time and attention today.
Thank you, Ms. Bryce. Representative Stevenson.
Thank you, Mr. Chair. I just want to turn it over now to Jenny Thiessen, who's seated here to my right. And in doing so, I want to just say that I think you're about to hear that the terrible ordeal she's been to. And it's just really remarkable, the strength and tenacity that she has brought through this entire process. And to be sitting here today and sharing this story, it's just really commendable. And I want to thank you for your leadership on this and for coming out and being willing to speak about this today. So,
Thank you.
Welcome to the committee, Ms. Thiessen. We appreciate your presence with us here today.
Thank you. Do I need to?
no, I think it,
I can fix it.
yeah, if you, they'll let us know if it's.
Okay. Mr. Chair, thank you for hearing House File 15 today and my personal testimony. My name is Jenny Hager, soon to be Thiessen, and I feel grateful to be able to address you and the entire committee today. Last year, when this bill was brought before the committee, I was sitting in the room listening. However, I was unable to testify as criminal charges were still pending against my former spouse regarding his actions. Since then, he has publicly admitted that he drugged me, he raped me, and he videotaped it in our Andover home. In March 2016, I discovered a flash drive containing several videos of my former spouse recording his coworkers in the private staff bathroom at his place of employment, and 2 additional videos of me in our home that I was unaware of. 2 months after serving my husband divorce papers and preparing my affidavit for divorce, I was tasked with reviewing every photo and video from a copy of our family laptop computer. I came across 2 videos that forever changed my life. They were videos of my husband had recorded in our bed, New Year's morning 2016. The first video starts out with a full screenshot of my vagina. My former spouse is forcefully inserting a synthetic penis in and out of my vagina for several seconds where my body lay lifeless. He pauses the forceful penetration and carefully crawls through the covers to reveal my face. My mouth is wide open, and it is clear that I am unconscious. He starts to move the camera back down to my lower body, and in that wider screenshot, my 4-year-old son is laying next to me in bed. He came back an hour later and started recording again for a second time. He put not only my life in danger, but was potentially exposing our son to something unthinkable. The worst part of that day was my mom was at my house when I discovered the rape videos. My mom and I sat and cried as I discovered I had been drugged and raped by my husband. No parent should ever have to experience their daughter in complete and utter pain, deception, confusion, disbelief. No one. Immediately after discovering these videos, I called the Anoka County Sheriff Detective, who was the main point of contact in the active criminal investigations regarding my former spouse. I was informed that someone would be following up with me soon to take my statement. Sadly, that was not the case. It took over 2 months of me calling the sheriff's office, talking to many different people, before I was finally scheduled to give my statement. In September 2017, I received a call from a victim witness specialist with the Anoka County Attorney's Office. She called to inform me that my former spouse had been formally charged with 1-count felony criminal sexual conduct in the 3rd degree. To be honest, I had mixed emotions when I heard this news. The strongest emotion I had was a feeling of sense of safety, not only for myself, but my 2 young children and our community, knowing that justice was going to be served. Later that afternoon, just as I was ready to head down to the bus stop to get my kids off the school bus, I received another call from that same woman. I could tell there was a shakiness in her voice, and she called to inform me that she had some news, and she said she was at a loss for words. But what she told me was life-changing. She explained that my former spouse's felony 3rd-degree criminal sexual assault charge was dropped because his criminal defense attorney made them aware at the county of a law on the Minnesota books that states a person cannot be charged with this crime if they were married at the time of the crime. She said the entire staff of attorneys in the office, the judge, sheriffs, no one knew that this law even existed. We were all shocked, and she said, "This needs to be changed." I was devastated and scared. That night, I struggled with the news I received. I watched some Harry Potter with my kids, and by the next morning, I was ready to go to work to make sure that no one in a similar situation hears, "I'm sorry, the charges have been dropped." The county was able to charge 5th-degree criminal sexual conduct and invasion of privacy, which was finally sentenced last month. My former spouse pled guilty to invasion of privacy and home. What he did to me was sexual assault, yet nothing shows on his record of the crimes he committed against me. Had he been charged at the 3rd degree, One of the requirements was registration as a sex offender. Yet nothing shows criminal sex on his record. In an excerpt from the sentencing court transcript from last month, Anoka County prosecuting attorney Paul Young is quoted by saying, "This court knows that the psychological evaluations that were done on my former spouse and the recommendations find him to be a moderate to high risk to reoffend. While we see other offenders with that, it is concerning given that before even reaching those conclusions, this is a person that had been in sex offender counseling, therapy, marriage counseling, and is still at a stage after all that time a high risk to the community. Since felony charges were dropped because we were married, not only myself, but our community is being put at risk from sexual predators like my former spouse." In closing, I would like to read you an excerpt from my victim impact statement read in court at sentencing for the invasion of privacy last month. In September 2017, my former spouse was charged with third-degree criminal sexual assault, and those charges were dropped because in the state of Minnesota, if you are married, you cannot be charged with sexual assault degrees 1 through 4, even if your spouse is incapacitated when the sexual assault takes place. And today, he has entered a plea of 45 days jail and invasion of privacy. At a minimum, he should have to register as a sex offender. More jail time is also warranted. The Star Tribune recently ran a series titled "Justice Denied" that examines how Minnesota's criminal justice system often fails victims of rape and sexual assault. With the plea agreement that was reached, this becomes one more story of a victim that has been failed. I would rather be in the victim heard, justice served category. Thank you, your chair.
Thank you, Ms. Thiessen, and I want to acknowledge the importance of you coming forward to assert your personal dignity and your humanity, and I want you to know that I see it and I acknowledge it. Thank you.
Thank you, Mr. Chair.
Representative Stevenson.
Thank you, Mr. Chair. I'd be happy to take any questions from the committee on the subject at this time.
Committee members, are there questions? Representative Edelson.
I want to thank you for your testimony, and I'm sure it wasn't easy to come here today. Would there be any going retroactive, any sort of, is there any language that can be added to this? Or have you thought about that?
Representative Stevenson.
Mr. Chair, Representative Edelson, the bill as it stands now is not retroactive. It would apply to instances occurring, I believe, after July 1st. Yeah, July 1st of 2019. I'm not sure that you could go retroactive on this particular piece.
Thank you.
Representative Pinto.
Thank you, Mr. Chair, and I too want to thank you for your really powerful testimony and for your willingness to put yourself out there on behalf of other people, and our state thanks you for that. And I want to thank Ms. Bryce and Mincas as well. I was actually involved in some of those earlier conversations a couple years ago, and the concern that potentially this could somehow impact a relationship, a consensual relationship involving a physical disability. I had some trouble with that at the time as seeing it, and I'm so glad that we've kind of collectively worked through that and realized that that's not a concern, and this is really a matter of justice, so thank you. And thanks to you, Representative Stevenson, and I feel like it is worthy of lifting up the original author of this bill from last session, our now Speaker, Melissa Hortman, who's been a champion on this, and of course, it's former Chair Johnson then who chose to include this in the omnibus bill last year, so this is a really group effort, but I appreciate that this session, Representative Stevenson has taken the lead on it, so thank you for that. Thank you, Mr. Chair.
Thank you, Representative Pinto. Representative Johnson.
Mr. Chair, this bill is supposed to be headed to judiciary next, is that correct?
Representative Johnson, the motion is to refer to Ways and Means, and the motion involves a recommendation that it be referred to judiciary.
Thank you. Mr. Chair, Representative, I do have an amendment I wish you would consider putting on in judiciary. This is an important issue. Instead of waiting till August 1st for this to go to effect, have an amendment put on it to, upon final enactment, goes into effect.
Mr. Chair, Representative, I would agree that that's an amendment worth considering.
And we have Chairman Lesh here, who's listening in on the conversation. I suspect that will be given some serious consideration at that time. Representative Johnson, are you? Thank you. Representative O'Neill.
Thank you, Mr. Chair. I just wanted to acknowledge how difficult and challenging and brave it was for you to bring your testimony today. And hopefully this is another bit along your road of healing. And you're a brave woman, so I want to acknowledge that and thank you. And thank you for bringing this bill forward. This is overdue, and I wish we could have enacted it a year ago. It's very sad that something like this didn't get signed into law when we had it through both bodies. And sadly, it was vetoed. So I just want to acknowledge your bravery and thank you for coming and sharing your story, as difficult as it was.
Thank you, Representative O'Neill. Representative Stevenson, I suspect that this year we'll pursue a different strategy in terms of trying to get this bill in front of the governor's desk, and hopefully we can do that sooner than later. Representative Grossell.
Thank you, Mr. Chair. And Representative, thank you for bringing this legislation forward again. It is something that needs to be done, something that needs to be addressed. And I just wanted to make one comment on one thing that really caught my ear. Victims heard, victims served. And that is something that, since I walked through the front door in 2016, been working on legislation for that very purpose, so that these predators, these sexual predators, and they call them predators for a reason, because they prey upon innocent people, people they can manipulate, people they can have authority over. So I want to thank you for your strength to come forward and testify, and I know it's got to be very difficult, but I have legislation that will illuminate these very people who get these plea deals. So again, thank you for bringing this legislation forward.
Thank you, Representative Grosso. Representative Considine. Chair Considine.
Thank you, Mr. Chair. To the testifier, your courage is amazing, and I'm really sorry that happened to you. Representative Stevenson, if the spouse is, say, has Alzheimer's and is in an institution, does this bill cover that? And who would then, frankly, speak for the spouse?
Representative Stevenson.
Mr. Chair, Representative Considine, what this bill would do in that situation is make the mere fact of the marriage between the person and the person who has Alzheimer's not controlling. If the sexual contact between spouses is still consensual, then it's not illegal. You know, consent is still a defense in that instance. And that, I believe, is why the disability community doesn't have a problem with this bill, because it still allows for people who are disabled or otherwise impacted to engage in sexual relations, provided there is consent.
Chair Considine.
Thank you, Mr. Chair. I'm guessing, unfortunately, I'm thinking of a case down in my area about 15 years ago where the woman was incapacitated, and her husband would come and pick her up and take her out for a visit. She wasn't capable of consent at this point in her life. And in fact, the tragedy was they both froze to death at the end of a long dirt road. That's somebody that's incapacitated and not able to give consent is what I'm thinking.
Representative Stevenson.
Mr. Chair, Representative Considine, I think ultimately consent is a big part of the touchstone of our or should be the touchstone of our criminal sexual conduct laws. I would also note for you that there is an element of prosecutorial discretion that exists in our laws that is meant to cover very extreme circumstances that might be applicable to a situation like the one that you are discussing.
Chair Considine.
Thank you for your answer.
And Chair Lesh, I suspect these are some of the issues that, you know, in your committee will dig deeper in terms of the technical application and considerations in terms of court and prosecuting procedures. So I look forward to that conversation in your committee.
Thank you for that. We will look at it, including the proposed amendment that came up. If Chair Considine has a question, he sits on that committee as well. I'll leave it up to you, Representative Stevenson, and you, Ms. Thiessen, if you want to endure another committee. I know that that's difficult, but I will tell you, you did an outstanding job today. And I know it's difficult. Those of us around here have questions about the idea of, re-victimizing the victim, whether that's the word you want to use or not. But I will tell you, a lot of times, you having to endure this again makes a huge difference for everyone here and makes for more solid legislation. It absolutely does. So I want to thank you for being willing to take this on your shoulders. For everyone who isn't in a position to speak up, thank you for that. So between here and there, Mr. Chair, we'll decide, how Representative Stevenson, you want to do this, okay? Thank you.
Thank you, Chairman Lash. Is there anyone in the public and the audience that wishes to testify for or against the bill? If not, then Representative Stevenson, I think we're ready to act on your bill. So Representative Long renews his motion that House File 15 be referred to the Ways and Means Committee with a recommendation that it be re-referred to the Judiciary Committee. All in favor of that motion, please say aye. Aye. Opposed, same sign. Motion prevails. Thank you, Representative Stevenson. Thank you, Ms. Thiessen. Thank you, Ms. Bryce. We see you and we hear you. Thank you for making yourself be seen and heard.
Thank you, Mr. Chair, and thank you, members of the committee.